The high relevance of this treaty for the world today continues to be all too evident, with developments in Iran, Israel, Pakistan, India, North Korea and other states. It's the focus of important work presently being done by the Honourable Gareth Evans to strengthen and renew the global commitment to practical measures against nuclear proliferation, which, if it continues, runs the risk of reducing all the world and all its beauties to ashes. Within the field of international human rights law, Whitlam secured the ratification of no fewer than 15 significant human rights treaties. It was his government that ushered in the modern era in Australia's engagement with enforceable international human rights law. The International Convention on the Elimination of All Forms of Racial Discrimination, CERD, entered into force on the 30th of October 1975. It's one of the most significant human rights treaties ever joined by this country. By joining it, Whitlam sent a powerful message to the world that Australian law would no longer accept any lingering relics of the White Australia policy, but would put in place measures designed to reverse the previous culture of this country of racial inequality. Other significant human rights treaties ratified by the government included the protocol relating to the status of refugees, and that has been a very fruitful source of business for the High Court of Australia, the Federal Court and all the other courts and tribunals in the nation. On the 10th of March 75, the government ratified the Convention on the Political Rights of Women. And another human rights treaty ratified by Australia was the Convention relating to the status of stateless persons. During the Whitlam government, the rights of employees within the context of human rights were also protected in a similar way. For example, in February 73, Australia ratified several conventions of the International Labour Organisation, and these conventions were later the foundation for parts of the federal industrial relations law, which was upheld by the High Court of Australia in the industrial relations case in 1996. Other ILO conventions included the one against discrimination in employment, number 111, the application of principles to the right to organise, 98, and other conventions relating to the equal remuneration of men and women. 3 international treaties were ratified concerning intellectual property. 7 key treaties were ratified dealing with international institutions. These regulated and assisted the resolution of disputes of an international character. For example, Australia deposited the instrument of accession to the Vienna Convention on the Law of Treaties, and that treaty codifies and updates the customary international law on treaties between states and applies to treaties concluded between states, and it's often referred to in the High Court of Australia in order to understand and interpret treaties, because it is the treaty on treaties. Remarkably, during the Whitlam government, Australia ratified 14 treaties, no less, on all aspects dealing with international air services. This was a comprehensive and rather delayed updating of the law in Australia and Australia's status as a large air travelling nation. Australia ratified 15 treaties concerned with labour standards. Between 72 and 75, we ratified 9 ILO conventions, and by way of contrast, the Fraser government, during its years of office, ratified only 1 in 7 years. Whitlam saw the approval and ratification of ILO conventions as a step towards the promotion and protection of human rights of Australians. He was not lukewarm on the protection of human rights of Australians. He said, "We've ratified ILO conventions dealing with equal pay, trade union rights, elimination of discrimination in employment, thereby ensuring Australians accord with all ILO conventions in the field of fundamental human rights. Australia's record, some 42 ratifications in all, compares favourably of that of all other federal states." But Whitlam's intellectual curiosity extended far beyond law. He secured ratification for at least 6 international treaties pertaining to science and technology, and in the paper they're set out. 8 treaties were ratified on aspects of taxation. 9 treaties were ratified dealing with the arts and aspects of cultural excellence. One of the most significant cultural treaties so ratified included the Convention on the Protection of the World Cultural and Natural Heritage, which became important in the Tasmanian Dam case. This placed a positive duty upon states to recognise and ensure the identification, protection, conservation, preservation and transmission to future generations of cultural and natural heritage by the state party. Under Whitlam, Australia also ratified 35 treaties dealing with trade arrangements, treaties on textiles, on sugar, on bauxite and on interstate negotiations. The list is almost limitless. And apart from the foregoing remarkable record in Australia's ratifications, the Whitlam government ensured that Australia was actively involved within the many organs of international affairs that were open to it. To this end, referring to his government, Gough Whitlam said, quote, "We see international law as an integral part of Australia's policy formulation and the projection of those policies international. We believe that international law, and by that I include not only the rules of international law, but also the lawmaking and law-applying processes and the formal and informal institutions, provide the only alternatives to tension, chaos, destruction." One of the fundamental policies promoted by Whitlam, indeed somewhat impertinently even before his election to government, was that Australia should enter into diplomatic relations with the People's Republic of China. He would never give up on that subject. Members of the coalition government at the time ridiculed Whitlam's efforts at realpolitik. Malcolm Fraser described Whitlam as being clearly the Chinese candidate for the next Australian elections. But Whitlam's visit to China as opposition leader had coincided with that of the United States Secretary of State, Dr. Henry Kissinger. And within days of Whitlam's visit, President Richard Nixon announced that he too would be going to visit Beijing. The coalition government of the time was caught flat-footed. It was still locked into Cold War policies of the Menzies era, and it was made to look out of date and out of time. So far as the international human rights law was concerned, Australia ratified a record number of international human rights treaties. The UN International Covenant on Economic, Social and Cultural Rights, the International Covenant on Civil and Political Rights, the two covenants intended to give effect to the principles outlined in the General Assembly's 1948 Universal Declaration on Human Rights, which had been adopted by the General Assembly on the 18th of December 1966, with Dr. H.V. Evatt of Australia in the chair as the President of the Assembly. In numerous other areas, the policy of the Whitlam government had been to foster respect for particular aspects of human rights. For example, the government negotiated the prompt emergence of an independent Papua New Guinea from colonial rule. Whitlam's championship of full self-determination for Papua New Guinea also manifested itself in his support for self-determination of Indochina. Indeed, this point was made at a time when it wasn't even an established political position in Australia, even within the Australian Labor Party. Whitlam was a champion of self-determination of previously colonised people. In 1973, the interest that the Whitlam government had shown for international law was translated into innovative proceedings in the International Court of Justice. Those proceedings concerned the French nuclear tests conducted in the Pacific. It was another example of Whitlam's innovative use of international instrumentalities. At the International Court of Justice, Attorney General Lionel Murphy led a team of Australian advocates to success in the result in which the ICJ ruled against France's claimed right to continue above-ground nuclear testing in the Pacific, a long way from metropolitan France. This was a dramatic vindication of the Whitlam government's bold move, which had been criticised strongly as futile, but which was found to be correct.